Good morning. Good morning, Mr. Barter.
Good morning, Madam Chief Justice and members of the court. May it please the court, my name's John Barter. I'm here representing the plaintiff appellant Global Naps in this case. As you can tell from the 7-volume record appendix, this litigation in a broad scope has a very long and tortured history. But I think that the issues we're addressing today are really quite discrete. This is a case that focuses on the question of whether or not the words of the Massachusetts Maternity Leave Act mean what they say. The Massachusetts Maternity Leave Act, Chapter 149, Section 105D, provides that certain benefits shall be available to a female employee who's absent from employment for a period not exceeding 8 weeks. In the underlying case here, the employee, Sandy Stevens, filed essentially a single-count complaint alleging that her rights under the Massachusetts Maternity Leave Act were violated. The Massachusetts Maternity Leave Act, as I mentioned, is Chapter 149, but it's enforced through the MCAD.
They say you should be equitably stopped because you encouraged her to take more than 8 weeks because she had a C-section. Why is that not an appropriate result here?
Well, the answer is, Your Honor, as I was saying, a single-count complaint was brought. It was under Section 11A of 151B. Section 11A applies to Maternity Leave Act claims. If Sandy Stevens had brought a claim under Section 5 of Chapter 151B, Section 5 relates to interference with or prevention of a plaintiff in exercising their rights. Now, all of the federal court cases to which the defendants allude had separate counts, separate complaints under the federal law, under the analog for interference with that.
But you didn't interfere with her. You didn't say, I'm going to retaliate if you were to bring this action. You said, you're welcome to take 10 weeks if you have a C-section. And then she took 10 weeks, and you said, essentially, sucker, you took more than 8 weeks, you're fired.
Well, I'm glad that Your Honor has bought into the defendant's argument. So,
well, isn't that what happened?
No, in fact, and I'm glad with the language that you're using.
Apart from not using the word sucker, isn't that basically what happened?
Well, I like the word sucker because it paints a picture of Global Naps as being this Simon Legree character, this horrible character who's tricking an employee into not gaining anything from the Maternity Leave Act. And that's definitely not what happened. As Your Honor said, and as the defendants say in their brief at page 1 and page 7, they say the employer guaranteed 10 weeks. All right, if you have maternity leave, we'll give you 2 extra weeks. 2 extra weeks brings us to September 18th. And she called in on October 2nd saying, I want to come back to work now. If we measure out the 10 weeks, if we measure out the 8 weeks plus the 2 extra weeks, it doesn't get to the point of when she said, I'd like to come back to work now.
Did you argue this in your brief?
Well, from my perspective, Justice Cowens, there's very little that Global Naps can do about the judgment that was entered in the Sandy Stevens case. We've already paid...
Oh, but it would have been interesting to know this. I mean, I read, I think, all the briefs, and this is the first time I've ever heard them, unless I missed this.
Well, essentially, we're collaterally stopped from saying we shouldn't have to pay. We've paid. We've paid her over, $1,130,000. That's water under the bridge.
I also didn't see anything, and again, I might have missed it, but I saw nothing in your brief about this sentence in the right at the end of Chapter 149, Section 105D. Nothing in this section shall be construed to affect any company policy which provides for greater or additional benefits than those required under this section. I don't remember seeing that stated in your brief. And doesn't that have some effect on this case?
Well, it's certainly a relevant provision. And
did you ever discuss it in your...
I did discuss it in the brief because the important part of that provision is it says that nothing in this chapter shall affect any
The section, it doesn't say chapter.
in
It's
this section. The Section 105D is what it's referring to, 149-105D,
Right.
which is the entirety of the Maternity Leave Act is within that section. And nothing in this section shall affect rights that are garnered from other sources. For example, under the Federal Family Leave Act, someone gets 12 weeks of leave. And the fact that they get 8 weeks under Massachusetts law doesn't mean they can't take advantage of the 12 weeks under federal law. Presumably, Sandy Stevens sought her relief under the Massachusetts law because in order to be eligible under the federal law, there has to be a minimum of 50 employees in the company. Being that this is a smaller company, she sought relief under the Massachusetts law. If there were a collective bargaining agreement, she would be entitled to whatever rights the collective bargaining agreement yields. However, the fact that there are rights from other sources does not mean that the rights garnered from other sources become statutory maternity leave rights. There are several issues in this case whereby Ms. Stevens could have filed a multiple count complaint. She could have said, under Section 5, I think there was interference with my ability to assert my Massachusetts Maternity Leave Rights Act, my rights under that act. They interfered by tricking me. I was suckered. They told me that I'd get 10 weeks, and when I called after 12 weeks, they wouldn't give me my job back. That's exactly the route that's used in all these federal cases. There's an analog to the interference section in the Massachusetts under 151B under the federal law. And the federal cases that have come up raising this estoppel issue have all brought counts and claims under the estoppel theory. Now, this court has said that a party asserting estoppel has a heavy burden. Estoppel is not regarded with favor. It must be raised at trial and not for the first time on appeal. This court has a series of estoppel cases showing the affirmative burden of the moving party to prove that there was an estoppel. No estoppel was asserted here.
It strikes me, I mean, you've laid out a fact scenario which I have to confess doesn't come across in the brief either, about the 10-week versus 12-week. I mean, I was sort of paying attention to the dates, but I wasn't doing the math. Isn't that important, because doesn't that bear on the issue of whether or not an appeal would have been successful? I mean, one of the issues we're trying to decide here is whether an appeal would have been successful, and if it would have been successful, then the failure to file appeal in a timely fashion may have been malpractice. Mm-hmm. Was this a contested issue at trial, the question of when she called? And
it was a contested issue whereby the evidence from the employer was, yes, we told her she could have the extra 2 weeks. And when she called at the expiration of that extra 2 week, when she didn't return after the expiration of that extra 2 week period, then the temporary employee that we had there, Daisy Alvum, we told her, well, Sandy didn't show up, I guess you can have the job full time. However, Your Honor, the reason this is important is there's nothing we can do as the employer about the fact that the jury chose to believe Sandy Stevens.
Well, that's
all water under the bridge.
But that's what I'm getting at. I mean, if it's a credibility question and the jury had evidence they could have concluded otherwise, that's really not something you're going to be very successful on at appeal.
No, but the important part about this is it doesn't matter.
Okay.
What Sandy Stevens said at the time of trial, she abandoned this extra 2 week theory, and she said, no, they told me to come back on October 2nd, which is, 12 weeks later. And as a result of her testifying to that effect, and evidently the jury believing her, it takes the matter even further outside. But the reason, Justice Cordy, that it doesn't matter is either of those dates,
the rights are not
whether it's 10
statutory.
weeks later or 12 weeks later, is greater than 8 weeks.
Mm-hmm.
But back to my point that I asked you before, the language about nothing in the section shall be construed to affect greater benefits. I see it in your brief in regard to the guidelines But that's when you're arguing that the guidelines extended the statute, the rights under the statute. I was just surprised that I didn't see it as part of the statute in your brief.
Well, Your Honor, the guidelines, and as I think I mentioned there, is the guidelines essentially are parroting what the statute says with regard to that phrase, that the nothing in the Maternity Leave Act shall affect rights garnered from other sources. My view is effect can mean many things. It doesn't mean what the defendants are saying is it should affect. What the defendants are saying is if you get rights from another source, then the rights from that other source are affected by the Maternity Leave Act because they become Maternity Leave Act rights. However, they're not. What this is intended to do, and what Ragsdale focused on as well, when the Department of Labor enacted certain regulations, those rights were quite analogous. They said, you have a certain package of rights given to you by statute. However, employers can give you greater rights. The states can give you greater rights. And the fact that other sources give you greater rights doesn't diminish or extinguish these rights. What the defendants are doing here is they're saying, if an employer says, I'll give you 10 years of maternity leave, that those are Massachusetts Maternity Leave Act rights, and that you're entitled to everything you get under the Massachusetts Maternity Leave Act, which is the opportunity to be enforced through the MCAD, a provision for attorney fees, the possibility of punitive damages,
but
the possibility of...
The MCAD didn't do that. The MCAD said if you give more than 8 weeks and you don't plan to promise them their job back after 8 weeks, you must tell them that. If you tell them that, you may do that. You just have to make sure that the employee is aware that after 8 weeks they may not get their job back under the Act. I mean, why is that not an appropriate thing for an agency to do? Well, let me ask you, let me go back. During the extra period that you gave her, did you pay her?
No.
Okay, so this is all unpaid leave.
Correct.
So you gave her 10 weeks, but if she took the 10 weeks, she would basically then lose the rights under the 8 weeks by relying upon the commitment that you gave, assuming credibility issues, putting that aside. Isn't that a problem, that you basically, the employer is taking away the right to come back by promising them what appears to the employee to be additional time?
It would be a problem if people were to be doing that. Our position at trial was is not what we intended to do, but we recognized
the jury found you did.
That's what the jury found. But the question is, if someone violates that provision, does that mean that the statute, which says 8 weeks, this is something that was negotiated by the legislature?
I take it your position is, it sounds in contract, not in statutory violation, i.e., somebody goes out for a disability other than maternity, correct, and negotiates, you have a knee injury. And I'm not even talking about contractual sick leave policy, but in other words, the employer says, you can stay out for 8 weeks, and there's nothing in any existing arrangement that permits them to stay out for 8 weeks, and at the end of 8 weeks they come back and their job is gone. I take it you would say that's a violation of something, maybe, but it's not a violation of it's just a contractual violation.
That's exactly right, and where
am I getting this right?
Yes, you are getting it right, Your Honor. What we're saying is,
and therefore you would be entitled to damages as may exist that are whatever the damages are under that contract.
Under the contract or the wrongful termination in violation of public policy or whatever count the plaintiff may have alleged in the alternative.
But maybe I'm just being very thick this morning, but why do we have to make that determination to resolve the underlying legal malpractice case?
Well, that's the beauty of it, is that you don't. The legal malpractice case was based on a very specific case, which is already engraved in stone.
Right.
The Sandy Stevens case, the case where the employer had a very strong appeal
Right.
based upon the statute, as Justice Muse, the trial judge himself, said, and where the statute was exceeded and where the employee got well over $1 million, which was paid. So this court's decision isn't going to affect this employee.
No, I understand that.
This court's decision is going to provide guidance as to whether or not the MCAD can. This isn't a regulation.
But
this
don't
is just
we
a
have to decide?
guideline.
Don't we have to decide in the malpractice?
Yes.
For purposes of the malpractice case, that had an appeal been perfected and taken, it would have been successful.
Exactly.
So we do have to decide the underlying issue, don't we?
You have to decide whether it would have been successful. But the only case that you have to decide whether it would have been successful is a single-count complaint for violating the Massachusetts Maternity Leave Act. You don't have to decide whether a breach of contract case would have been successful or whether a interference case under Section 5 would have been successful.
It is relevant, it seems to me, in this case to suggest that there was no other ground of relief. And what you're saying is, well, I'm suggesting there are other grounds
Yes.
of relief, but it's just not that single-count complaint.
Exactly. There were many other potential grounds for relief which were not asserted.
Wait, was she an at-will employee? Was she at-will?
Yes.
But it doesn't make any difference. You can be an at-will employee, the argument would go.
But there can
and
still be wrongful termination.
Yes, because somebody says you can go for 8 weeks for your knee, and then you come back at the end of 8 weeks, and maybe the argument, that's a factual argument, not 8 weeks, it was October the 2nd or something, and there's a dispute about that.
Right.
But is there a breach of contract? But then there's no breach of contract claim.
Because she never alleged it.
Because she's an at-will employee?
Yeah.
Well, the breach of contract would be the contract that we shall bring you back.
Promise.
The oral
It's
agreement.
a promise, an oral promise, one might say.
Based on the fact that that hers was a single count complaint, the only thing that she could have recovered for was a violation of the Maternity Leave Act.
Correct.
And after 8 weeks had passed, it was outside the scope of that whole issue.
Correct.
That's your argument, correct?
That's my argument, Your Honor.
And if we agree with you on that, does everything else fall into place, or do you go back? This is a summary judgment, correct?
Yeah, I believe everything falls into place. The defendants take a different position. The defendants say, well, even if you won, the appellate court would have simply remanded it so Sandy Stevens could have a new trial. I don't understand why one would do that. This court's practice has always been where a motion for directed verdict should have been allowed and was denied. If the court so finds, the case is remanded for entry of judgment in favor of the party that should have prevailed
But
at
how
the
was
time of trial.
how was the case tried? Was it tried under the contract tacked
No.
on to the
There was no contract claim brought at all.
No, I know there wasn't one articulated in the complaint, but could the plaintiff have filed a motion to amend the pleadings to conform to the evidence?
Well, this court has...
Isn't that what they're saying?
That may be what they're saying, but the plaintiff didn't
Do that.
file such an amendment either after the jury came back or before the jury came back, nor did they ask for it in a prayer for relief in the appellate brief that they filed.
And you're saying they can't do it now?
I'm saying they can't do it now, and I guess it's particularly clear that they can't do it now because the case is some time ago and she's already been paid well over $1 million. So the question is, would this court likely have remanded the case with instructions that an employee who brought a single-count complaint should be able to come back and assert several new counts that she chose not to bring in the first place? And I think that the answer, based on this court's firm practice over the years, is that wouldn't have happened.
So your view is that you win if the appeals court would have said she loses and has no remedy?
Yes. Thank you very much. I know my time is up.
Thank you, Mr.
If you have any
Barton.
questions, I'd answer them, but thank you.
Mr. Goodman, good morning.
Good morning, Your Honor. Let me start by thanking the court for permitting me to appear pro hoc vice. Very much appreciate the privilege. The reason this is not a contract case,
No, nobody suggests it's a contract case.
esteemed brethren, I think relies on the fact
No, he's
that
just looking to whether or not, once you get out beyond the 8 weeks, there's some other basis on which you can have a claim against an employer, correct?
Precisely, Your Honor, but we're not, but the basis of the Stevens claim was not for the additional 2 weeks. The basis of the Stevens claim was that the conduct by Global completely deprived her, by her reliance on their representation, of her right to the 8 weeks under the Maternity Leave Act.
Just say that again.
The key in the Stevens case,
Right.
as was tried and as is reflected throughout the record, and I'll give the specific
Sure.
sites, is that Ms. Stevens argued that her 8 weeks, she was deprived of her 8 weeks under the Maternity Leave Act in reliance on the representation of the extended benefit. It's kind of like the gotcha situation.
No, but she got 8 weeks. There's no question, right?
No, there is a question, Your Honor. There is a question whether or not she would have returned within the 8 weeks had she known, in fact, that she was being limited to 8 weeks.
It's sort of like a detrimental reliance theory.
That's right, Your Honor.
Was that argued in the complaint?
Well, it would have come up in the complaint it wouldn't have come up in the complaint, Your Honor. It comes up by way of responding to an affirmative defense in the answer. The issue is raised by an affirmative defense. Slow down. I know.
Finish,
Okay.
and then.
The issue came up as a result of an affirmative defense in the Global answer. On page 141 of the record, Global's answer alleges that it's protected from the suit by its compliance with the Maternity Leave Act.
Right.
So at trial, the evidence was, did you comply with the Maternity Leave Act?
And the answer to that is yes.
And the answer to that is no, Your
Okay,
Honor.
so let me, here's my hypothetical. There's a minimum wage law in this state, right? I don't know what it is. Forgive me, I just don't. So let's assume it's $10 just to make the numbers easy.
Can I move here, Your Honor?
I was being protective. So it's $10, and I promised to pay somebody $20. I paid them $12. Can they bring a claim for under the Minimum Wage Act?
Well, but what if, Your Honor, and let me, if I can, come back to the
Or
hypothetical.
if I say, I'll never pay you less than minimum age, but in fact I'm going to pay you 20, and then I end up paying you 12.
And now let's go through a whole range of questions on that, Your Honor.
Okay.
One question is, did I leave a job that paid me 15?
She didn't leave the job.
Did I, well, that's right, she didn't leave the
Well,
job.
let me interject one question in your series. Are the rights under the Maternity Leave Act, is it unpaid leave?
Yes.
It's unpaid leave.
So she wouldn't have gotten paid anyway.
She wouldn't have
No,
gotten
and that's
paid.
not the complaint. The complaint was the reinstatement question.
But I mean, you can ask me any questions you want to ask, but it seems, just tell me why I shouldn't think of it that way. In other words, there are very salutary public policy things that give minimum protections, and then there are all kinds of employers who offer to give more. There was a dispute as to whether they offered to give 10 weeks or until October the 2nd. That's a factual dispute. I don't have any question about that. And as Mr. Barter says, then, you know, you finish. Why is that a claim under the Mass Maternity Leave Act?
Because this case
Right.
is as if that she got paid $8, not $12, or $5,
Why?
not $12, because she was denied the entire 8 weeks.
How was she denied the entire 8 weeks?
Because she said she wanted to come back before the 10 weeks. She was told, wait until the 10 weeks. And then when she waited, and she called while she was out, there was nothing that said come back earlier. And then when she called after the 10 weeks, she said, oh, it's too late. We got you. You missed the 8 weeks.
So she asked at week 6?
No, she called right after giving birth on August 2nd, which was well within the period within which she could have returned within the 8 weeks. So the way the testimony laid out at trial, Your Honor, on page 1153 of the record,
Yeah.
Ms. Stevens specifically stated, testified as follows. So Janet fully understood that, and she said, but because you might have a C-section, you're going to need more than 8 weeks. So I will give you to return back October 2nd, 2000. Then I stated to her, this is Ms. Stevens testifying, I said, no, Janet, if I should have a regular birth, I will be back at the house way before you know October 2nd, 2000. And then she stated, well, if you should have a C-section by July, by September, Natasha, her other daughter, would have returned to school, and by October 2nd, you should have been completely healed to return to work. Then
I thought you told me she had called after the birth.
I did, and it said 1158 of the record. The first I just read, Your Honor, was 1153 of the record. This is the follow-up testimony on page 1158 of the record. This is question. And you had a baby on August 2nd, and the conversation you had was when with Janet Lima, who was the chief HR person of Global? Answer, I had called my husband and myself. We called Janet that same day when I had the baby. Later on, maybe around 9, 10 o'clock. I was up and I called Janet, and my husband actually dialed the number and gave the phone number to me, and I guess he spent with Janet for a short time, blah, blah, blah. Then she says, hi, Janet, I had the baby, and she said, oh, congratulations. She said, how was it? Are you a little bit sore? I said, yes, I had a C-section, and she said to me, that's awesome. I will pass the news. I will let Paula and Frank know that you had the baby. We had a little chit-chat, a little bit on the phone. That was before the end, and that was before the end of our conversation. Janet said to me, Sandy, please feel free to call me if you need anything, and that was the last time I spoke to Janet. Now, in your analogy, Your Honor, if in fact Ms. Lima had said to Ms. Stevens, in that call on August 2nd, we need you back within the 8 weeks.
She can't have her back within the 8 weeks, right? She's entitled to 8 weeks.
No, I said we need you back at the 8 weeks. Okay. Then the analogy that Your Honor said would be apt. And then the argument proffered by Global might have some probity to it. But the fact that...
No. I literally don't understand that, because if somebody says, I'm going to pay you $10, I have to pay you $10, but I'm offering to pay you $20, and I give you $12, why, I mean, I don't understand why that gets me down to $6.
Because the question focuses on, Your Honor, should Global be able to profit by its own misstatement to...
the answer to that may be no.
That's right. And the answer to that is no under the MLA and under the guideline.
Why under the MLA?
Because under the MLA, by relying on all this conduct, by relying on the promise of 10 weeks, by relying on the silence when she called after the birth, and not returning within the 8 weeks, Ms. Stevens was induced to forgo her 8-week right on maternity. Now, this case has never arisen before under the MLA. It has arisen under the FMLA, under the federal courts.
So I take it what you're saying is that the case that you have just articulated falls within the single count complaint alleging a violation of Section 11A.
Yes, it does,
and
Your
you
Honor.
do not have, your plaintiff, or Ms. Stevens, did not have to bring a case under Section 5.
That's correct, Your Honor. And because under 11A, the violation says, for an employer himself or agent to refuse to restore certain female employees to employment following their absence by reason of maternity leave, or to otherwise fail to comply with the provisions of said section. There was an affirmative defense alleged that there was compliance with the section. The evidence at trial was that there was not compliance with the section because Ms. Stevens was induced not to come back within the 8 weeks because she was promised 10 weeks. Now, that has come up not in this state. It's come up in the FMLA context. And in the FMLA context, and by the way, there was nothing in the briefs about the whole inducement. Justice Cowan was right on that point. But it's come up within the FMLA context in both the Fry case, which is in the record, actually, and in the Wilson case from the Sixth Circuit, almost exactly foursquare, where there was a representation made in one case. It was actually in the employee handbook of leave beyond the 16 weeks, beyond the 12 weeks to 16 weeks, and then in fact
those didn't tell me what the complaints were.
The complaints were in those cases FMLA complaints for the
Single,
exact same thing.
only FMLA complaints?
But the discussion in those cases was broken down by cause of action, and the FMLA cause of action in those decisions was discussed separately in each of those decisions.
Do you agree that if Mr. Barter's argument, if we agree with Mr. Barter in order for detrimental reliance to become an issue in the case, there would have had to have been a count alleging a violation of Section 5. If we agree with him, do you agree that he wins?
No, Your Honor, do not. Because this evidence comes in and came in at trial as a response to the affirmative defense and the answer that there was compliance with the MLA. And the assignment of error was in the failure to grant judgment NOV or directed verdict and in alleged improper instructions. By the way, all this goes away once we give substantial deference, as this Court has articulated on the guideline.
Why on this point should we give substantial deference to the agency? Because it's just the statute.
Because it's not contrary to the statute, Your Honor. All it says, as Justice Gantz pointed out earlier, was if you're going to give more, just put everything in writing so you don't mislead your employee.
But I take it your better argument is that there was detrimental reliance here, which she relied upon, or there was a representation that she relied upon and forbore exercising her rights under the statute.
I think they're both strong arguments, Your Honor. We think that either one independently, the decision below should be affirmed. There is a basic equitable sense that Global should not be allowed to take advantage of its own wrongdoing here. We are bound based on...
That may be. Please understand, that may be. Right? The question is, why is that a violation of the statute? That's the issue.
Because the conduct deprived Ms. Stevens of her 8 weeks leave under the statute. Because the evidence, and this was stated by the trial judge in the Stevens case, and again reflected in the decision below in this case, that because of her, the detrimental reliance theory, if you will, because of her reliance on misrepresentations by Global, she was induced to forego her 8-week MLA leave benefits. And never before in this state has that occurred. The guideline is designed solely to protect against that kind of misrepresentation, which is why it's reasonable and why deference should be paid to it. And in the two cases where it has arisen federally, there was the fine for the employee. Thank you very much, Your Honor.
Thank you, Mr. Goodman. Good morning, Ms. Marks.
May it please the Court, my name is Catherine Healy-Marks from Nelson, Kinder, Masso, and Satterley, and in this matter I represent Martha Awiszus and the firm of Winokur, Sirke, and Rosenberg. I'd like to use my time to address 3 points. On the first point, I will defer to Mr. Goodman's argument on the MMLA and the appropriateness of the MCAG guideline.
And you're saying, therefore, there was no likelihood of success on appeal?
Yes.
Okay.
And for that reason, any legal malpractice claim has to fail. Second, my client, Martha Awiszus, has an additional defense to any claim of malpractice because the record shows that she was the trial counsel, and then after trial, Jackson Lewis was brought on as appellate counsel.
But if we agree with what was just argued by Mr. Goodman, we don't have to reach these other issues. Am I correct?
Yes.
Yeah, that ends it.
Yes. So, and I believe that you won't have to, but I'd like to point out that even if you do, Ms. Awiszus should be insulated from any liability because she was the trial counsel, and
Had her notice of withdrawal been filed?
I'm sorry?
Had her notice of withdrawal been filed?
No. Her name appears in signature blocks on pleadings post-trial, but her name was inserted in those pleadings by Jackson Lewis, and any signature there is
She may have a
initialed.
claim against Jackson Lewis.
Well, our point is that her post-trial role was extremely limited, and
Doesn't make any difference for these purposes, does it?
well,
Isn't she in the case until
Yes.
her withdrawal is approved? So, I mean, isn't it just as likely that Global Nap's got two lawyers, two sets of lawyers from different firms?
Right, that's what they're claiming, but her affidavit, which appears in the record,
But why isn't that a reasonable conclusion to draw in light of the rule that a lawyer is in the case until the withdrawal is allowed?
Our argument is that when appellate counsel is retained specifically for the purpose of the appeal.
I understand that, but that unfortunately doesn't comply with our mass rules of civil procedure.
Okay. And
So you
in
want to
that
make your
case,
third argument?
at the very least, Global argues that the motion judge's grant of summary judgment in defendant's favor should be overturned and that they should get summary judgment in their favor. We would argue that that is completely inappropriate given Ms. Awiszus' very limited role, that at the very least, expert testimony would have to be heard on the scope of the scope of duty owed and the standard of care owed by a lawyer in her specific circumstances who had been replaced as.
Again, isn't that more appropriately a cause of action that she might have against Jackson Lewis or anybody else, rather than here?
I mean, in order to prevail on a malpractice claim, Global would have to demonstrate that she had a standard of care that she owed to them and that she didn't, and that she deviated from that standard of care. And they haven't presented any evidence regarding the specific scope of her representation. So at the very least, they should not be able to win their claim of summary judgment in their favor. But again, as Justice Cohen pointed out, we don't believe that you even need to reach that because the verdict under the MMLA should stand.
Thank you very much.